Hello and welcome to Legal Basics with Sarah Law Global, and my name is Sian. Now, among the questions that came from season one was the issues around summary dismissal and the distinction between a summary dismissal and a regular termination. And with us is a colleague in the profession, very sharp fella, very sharp, razor sharp, and he'll help us to understand these concepts and to make that distinction. I will let him introduce himself.
Great, thank you. Thank you for having me. My name is Anthony Leshan. I'm an advocate of the High Court of Kenya. I practice law in this country. I work with CMS Dali in Amdar Advocates in Nairobi.
Ivy League.
Yeah.
All right. Anthony, I call him Tony sometimes, forgive me. Please define for us, what is a summary dismissal?
Well, summary dismissal basically is dismissal or termination of a contract of employment without giving the employee the notice that they're entitled to, either under law or under their contract. Okay, so either without giving notice or giving them shorter notice than they're entitled to. Okay. So if I may explain, if someone is entitled to, say, 2 months notice in their contract, if the employer decides to terminate their employment and gives them 1 month notice, that is summary dismissal. If you give them no notice at all, that is summary dismissal. Yeah.
Okay.
Yeah.
Are there instances where the law allows for an employer to summarily dismiss an employee?
Yes, there are instances, but very limited. And in fact, summary dismissal should be very sparingly resorted to by employers. So there are basically, in general, two instances, okay, where the employee has fundamentally breached a term of their contract of employment, or there has been gross misconduct on the part of the employee. So you can see the gravity of the action that the employee has, needs to have done, has to be quite
heavy,
substantial. Yeah.
Okay.
Yeah.
Just as an example, what would amount to fundamental breach? Maybe just an example.
Yeah. Well, fraud, for instance, some employees may defraud their employer. That's a fundamental reason. Some employees may be very abusive or insulting even to their superiors.
Yeah.
That's another very substantial reason. Some people may undermine their employer's business in very significant terms. If you leak out
confidential
information, that is something that can be considered
a fundamental breach.
Yeah, and the list can be endless. It's not necessarily, although the law, if you look at the Employment Act, lists a number of examples, that list is not exhaustive. So it will be up to the employer to weigh the circumstances and the action of the employee and just to take an objective decision as to whether that amounts to gross misconduct or a fundamental breach
of their contract.
Yes.
So now, if an employer is convinced that whatever the employee has done meets this threshold, that it either fundamentally breaches their contract or it amounts to gross misconduct, how do they go about a summary dismissal?
Yeah, so in terms of process, this process will normally be found either in the law, that's the Employment Act, or in the contract that the employee has entered into. And when we say contract may incorporate human resource policy manuals, which
apply to the employee.
Collective bargaining agreements, where you have employees being members of certain trade unions that have negotiated collective agreements. So this process can be set out in a number of documents. Okay. But generally speaking, what the employer should do when you realize that there's been gross misconduct or fundamental breach is to set up a disciplinary hearing. Okay. And you start that by issuing the employee with what we call a notification of disciplinary hearing. It's basically a letter telling the employee, look, we feel that there are these reasons why your employment is at risk. You know, we will have a disciplinary hearing on this date at this venue to offer you the opportunity to respond or to give representations in answer to this allegation. So you start off with a notification, and then you will hold the disciplinary hearing. Okay. So at the disciplinary hearing, the employee will come, and normally they have a right to be accompanied by someone else, probably another co-worker. If they are members of a trade union, they can be accompanied by someone from the trade union. Okay.
An advocate?
That is a touchy area. Sometimes we've seen case law where you can come with an advocate, and we've seen instances where employers also bring their own advocates. So you have two advocates at the meeting. But sometimes that's not really helpful because, you know.
What does the advocate know about that gross misconduct?
You know, so so at the hearing, the employer will explain the reasons why they feel there's gross misconduct or fundamental breach. Okay, if they have any material to support their allegations, they should table them. Okay, so that the employee is given a very full picture of the allegations against them. Okay, then the employee will be given an opportunity, or should be given an opportunity, to explain themselves. Okay, why they feel there's no gross misconduct, why they feel you know, there's no fundamental breach, and if they have any evidence,
and why those facts maybe challenge the facts.
The person they have come with also should be, you know, if they wish to make any representations, you know, they can do that. If they wish to ask any questions, they can ask the employer questions. What they can't do is to answer questions on behalf of the employee. For instance, if the employer asks the employee questions, you know, you can't keep quiet and say, let my...
were you at work on Wednesday? This other can say, he was here. It has to be you.
Yeah, so that process, disciplinary process, is basically a process to gather information. So after that, the employer or the committee, normally sometimes it's a disciplinary committee, so they'll recede or, you know, take the information, go and consider what are the allegations, what's the evidence of the allegations, what are the answers, and what is the evidence that they've provided, and then take a decision. So the third step is to take a decision. Do we terminate this employment? If you come to the conclusion that, look, the explanations given are not so, you know, seem to be
sufficient,
very good, then sometimes you can let the employee off without, you don't really need to terminate. You can issue them with a warning letter if
it's a small thing.
A small thing. A warning letter can even be, you know, it can, some contracts, especially some HR manuals, will even require, look, let there be a first warning letter, let there be a second warning letter. Then if the misconduct continues, terminate. Okay. So yes, the committee will have to take that decision after the disciplinary hearing. But if they find that there's gross misconduct and fundamental breach, they're entitled to terminate the employment of the employee. And summarily, what that means is they issue a letter saying, look, your employment ends today. Okay.
Yeah.
Or, yes, you're entitled to 1 month notice, but your employment will end in 2 weeks' time. That is still summary.
It's still summary dismissal. Before we get to now this point where they decide, you know, you have to go. In that disciplinary panel, is there a legal threshold for who sits there?
No. The law itself, if you look at the Employment Act, it doesn't tell you who should sit there. But the composition of that panel is normally, you know, dictated in most human resource manuals. Okay. So you look at the HR manual, it will tell you these are the people who will sit at the panel. Of course, and the number also. Okay. So depending on where you're placed in the hierarchy of the organization, these people will normally either be at the same level as you or slightly above.
Okay, I've seen some case law where the person that is accusing you, if they sit on the panel, then that becomes a reason why the court nullifies that process, because they say you can't be the accuser and be the person that decides. You have to be impartial, right?
Exactly.
Okay. So now you've sat in this panel, and
Yeah.
the panel has decided, this guy has been coming to work drunk every day.
Yeah.
You've been found guilty and you have to go.
Yeah.
And they've told you you're going today. And maybe no notice.
Yeah.
Now, for the employer who is summarily dismissing an employee,
Yes.
what are their obligations as regards to remuneration?
Okay. As regards remuneration, the employer should pay the employee their salary up until the last date of employment.
There's no payment in lieu of notice.
There's no payment in lieu of notice. There's no obligation to give notice. And really, there's no payment in lieu of notice.
Okay.
Yeah.
So now, just generally, just going back to the questions, what would you say is the distinctive feature that sets apart a summary dismissal from a regular termination?
Yeah. What you call a regular termination is what is called termination on notice.
Yes.
Okay. So the distinctive feature is, number one, the grounds, the gravity of the offense that has been committed.
Yeah.
Okay. So for summary dismissal, we normally require
very high threshold.
Very high threshold. For less offenses.
Yeah. It would be a
termination on notice.
Yeah.
So the reason. Okay. Then in terms of the payout or terminal dues, termination on notice, you can get things like
payment in lieu of notice.
Yeah, which you really don't need to get in a summary dismissal situation.
Okay.
Yeah.
Okay.
So those are the two distinctions. What should be there for both is process. Okay.
There must be process.
There must be. You must be notified of a disciplinary hearing, and you must be afforded an opportunity to be heard.
In both occasions.
Yes.
Yeah, actually, that's important to point out, because some people assume that the fact that it's a summary dismissal means that I found you guilty out of my office. You know. So for both of them, there should be due process.
Exactly.
All right, that brings us to the end of our broadcast. As you've seen, this guy is sharp. So if people want these concepts expounded, and they're likely to, how can they reach you?
Well, they can reach us at our website contains if you just go to CMS Law. Okay.
CMS Law.
Or go to Google, type Dali Namdar Advocates. You'll get our website there. It gives you our contacts. We're in Nairobi. We're in Mombasa also. So wherever is closer to you.
Hamna kakijiji, ka ofisi kakijiji?
No.
Kama kule kwetu Kajiado.
We are thinking about one.
Are you? Welcome to Kajiado Daily and Inamda.
All right.
All right, viewers, if you want to reach us, or if you also want to propose that their firm comes to your village, you can write to us at info@cyroglobal.com. That's info@cyroglobal.com. Or you can write to us through our old Gmail address, that is cyrolawglobal@gmail.com. We would like to say thank you to our videography crew for the great work they do for us. They will display their address on the screen, and to J. Ojuma Advocates for facilitating the shooting of this series. Thank you so much. Share, subscribe. This information is very important, especially in these times of COVID where employment issues are so many. Bye-bye. Take care of yourself. God bless.